Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
I'm Hilary Page, and this is my colleague Danielle Murray. We're employment lawyers in Ontario. We are a virtual employment law firm. We only do labor and employment law, and we've always been virtual. So we're coming to you from our various locations across the province today. And we are presenting today, obviously, on COVID-19 and FAQ for employers. Sorry, I'm just making sure everyone can hear us. Looks like it's going okay so far. Yeah, so we did up a big FAQ based on employer questions that we were getting from our clients. There are obviously a lot of changes happening in the work world right now, with businesses having to close, revenue streams totally drying up, and the question of what do I do with my employees in this situation where you may have no work, you may need to change working arrangements for them, or whatnot. So that's what we're talking about today. We also have the, I think it's an 8 or 9 page FAQ resource on our website on the resources tab, with more detailed answers to some common questions we were getting there. So I encourage you to check that out. You can also download this presentation from the handouts tab of the webinar, so the PDF of that. And obviously we're going to be running over time since we're 15 minutes delayed now, but we're also going to try to make time to answer a few questions if there are any. So we may run a little bit over. This is intended to be a 30-minute presentation, and that's what we normally do. We do these every month, but yeah, just given the exceptional circumstances today, I think we might go a little bit over. So, okay, I think we'll just jump right in, Danielle, with our roadmap.
Good morning, everyone. So, like Hilary said, we recognize that this is a particularly stressful time right now if you're an employer. And so we're here to provide you with some up-to-date information on what the current law is and what your options are, whether you're staying open or if you need to temporarily close. So just an overview of what we're going to talk about. We're going to talk about if you're staying open for business, what your options are, reducing staff if you need to do that or if you need to close temporarily. We're going to talk about layoffs versus terminations, EI, time off, vacation, and benefits, what the requirements are there. Accommodations, discrimination in privacy, business operation concerns, remote working, given that this is a reality for a lot of people right now. And we're going to provide you with some resources at the end. So if you are staying open for business right now in some sort of capacity, you can require your employees to work. So we've been getting some questions about that. And the thing is, while you can require your employees to work, there have been some announcements, I believe it was Monday, from the provincial government saying that they are going to protect workers, and we're going to be talking about that a bit later. But if an employee is feeling sick, the employee could let you know that they're not coming into work for the foreseeable future, for the next while, because they're feeling sick. And in that case, they don't need to provide a doctor's note. So that's just a recent amendment that's been made. There will be some government funding for personal protective equipment, so you can look into that. So that would be for employees that are continuing to work, such as face masks and other things. And if you are staying open, if you are requiring your employees to work at the office or at the workplace or at home, for that matter, you still do need to pay your employees. And we're going to address reduction. So if you're reducing hours, we're going to talk about that a bit later, about a work sharing program. In terms of reducing pay, generally you can't really reduce pay if your employees are working the same hours. If you're in a situation where you do need to do that, you're in a position where you need to reduce people's pay, we would recommend that you reach out to us or to an employment lawyer. And then benefits, in general, you still do need to pay benefits, but again, if you're in that situation where you're not able to do so, we'd suggest that you reach out.
Yeah. Okay. So temporary closures and reducing staff. So a lot of businesses are in a situation where they just aren't able to operate anymore, or they're having to significantly scale back just because of, everything that's being canceled. So there are sort of a couple options available here in terms of how to reduce staff. So layoffs are one option. A layoff is a temporary layoff. So everyone's pretty familiar, I think, with the meaning of the word layoff. But it's the employee just isn't working anymore. The employer does not have to pay them. They're generally able to go on EI. A layoff needs to be enshrined in the employment contract. So the right to lay off needs to be in the employment contract or the collective agreement. It's a lot of employers don't have employment contracts, or they don't have that layoff provision in their employment contract. If you're in a situation like that and you feel like you need to lay someone off, we can talk about workarounds for that. And then termination is the other option here, which is permanent, basically. So a layoff, someone stops working, but the expectation is that they're going to come back. A termination is that's the end of the employment relationship, and that's going to trigger termination entitlements. So what we call notice or a severance package. Most employees are going to be entitled to something like that on a termination. They're not entitled to those benefits or that sort of package in the case of a layoff. And we're going to talk some more about this leave that was announced on Monday. So the law actually hasn't been amended yet to include this leave, but we're expecting that's going to come, and that would provide job protection for employees for sort of COVID-19 related reasons. So that would make it impossible actually for employers, or it would be contrary to the Employment Standards Act for employers to terminate somebody in a variety of circumstances, which we're going to cover when we talk about the proposed legislative amendments in a minute. So layoffs, just a couple more things about layoffs. They're temporary, right? So they can't sort of last for an indeterminate amount of time. You don't need to know when you're going to be recalling your employees when you lay them off. So you issue an ROE, which is a record of employment. You put that code layoff or shortage of work on there, and there is a spot for date of recall, and it's acceptable to put unknown in there. We don't know when restaurants are going to open again, or when we're going to be able to recall people back to work. Every province has different requirements in terms of how to do a layoff, what the requirements are, and how long it can be. So in Ontario, the sort of basic layoff is a maximum of 13 weeks in a 20-week period. It can be longer. It can be less than 35 weeks in a 52-week period if there are some conditions that are met. And the conditions are things like you continue the employee's benefits while they're on the layoff. If a layoff goes longer than this, then that's a termination, and the employee becomes entitled to termination entitlements, so like a package, as we would sort of colloquially call it. I just wanted to mention, I think we have some viewers from Manitoba today. So a layoff in Manitoba has a maximum duration of 8 weeks in a 16-week period. BC's 13 weeks in a 20-week period. Alberta, 60 days in a 120-day period. So, wherever you are, figure that out. Usually the governments have pretty easy to understand websites with these types of information on them, but it really does vary from province to province.
Okay, so this is some detail on the proposed amendments that Doug Ford announced on Monday. Not Rob Ford. And what's that?
RIP.
Yes. So this is what was announced on Monday, and it's still, just a proposed amendments to the legislation, but they are going to amend the Employment Standards Act and allow provide job protection for employees who are unable to work for the following reasons. So there's if the employee is under medical investigation, supervision, or treatment for COVID-19 and can't come into work, the employee cannot be terminated for that reason. The employee is acting in accordance with an order under the Health Protection and Promotion Act. The employee is in isolation or quarantine. The employee is acting in accordance with public health information or direction. And this one is an important one here. The employer directs the employee not to work. So if that's the case, the employees are entitled to not be terminated. The employee needs to provide care to a person for a reason related to COVID-19, such as a school or daycare closure. And these changes will be retroactive to January 25th, which was the date that the first presumptive COVID-19 case was confirmed in Ontario.
Yeah, so I just wanted to make a comment here. We literally don't know anything about what this new legislative amendment is going to actually look like. The only information we have is the same as everyone in the public, which is just basically the provincial news announcement. But I think that the reason the employer directs the employee not to work is quite broad. So that could really allow people who just their business where they work is closed and so they can't go to work. I think that will allow those people to use this leave. And a job protective leave is just like a parental leave. The employer won't have to pay the employees who are on this leave or anything like that. It just means you can't terminate somebody because of one of these reasons. So just I think it's pretty clear in all of our minds, we can't terminate someone who's on a parental leave. Just there's a job protection for that. Same exact thing is what's going to be going on here.
Okay. Yeah. Thanks, Hilary. So Trudeau announced yesterday that there will be some income support and $10 billion of federal assistance for businesses. And he said that there is the possibility of recalling Parliament to pass legislative measures regarding EI and employment-related issues. Unfortunately, that's as much as we know at the moment. We're expecting to hear more on that hopefully today or in the coming days. But at the moment, unfortunately, we're still just waiting to find out what those measures are going to be.
Yeah, everyone's kind of scrambling. Obviously, I forgot to mention. I think that the Employment Standards Act amendments that we just chatted about on the last slide. I believe that the idea is they're going to become law tomorrow, so that we'll keep you updated on that on our blog, but it's pretty fast to make a new law. Employment insurance. So this is something that employees who are on a leave, employees who are laid off, or employees who are terminated or employees who have their hours reduced potentially are going to be able to avail themselves of. There are certain requirements for EI, and those really depend on how many insurable hours that employee has banked, which is just how much they've worked, how much they've contributed to the EI program. That's going to determine their eligibility in most cases. So in order for employees to get employment insurance, the employer needs to issue the ROE, which they have to do anyway, and you'll have to do that in the circumstance of a termination, a layoff, or a leave. So code A is what we would use as the reason code on the ROE. If we're doing a layoff, that's code A, shortage of work. And then, as I said, there is that expected date of recall box, but if we don't know, and it's acceptable to put unknown in there. Code M is where an employee is terminated. So if the employment relationship is permanently ended, we can use code M. Some employers use code A. It's, if you're confused about that, you can get in touch. And then the COVID leave, we expect it will have its own code as well, but we don't know yet. But there is a special code for like parental leave, so we're expecting there to be a new code for that when we're able to start using that leave. And just because it's retroactive to January 25th, like it's maybe we could even use it now. Who knows? So there are different types of EI. There are sickness benefits, and the federal government has announced that sickness benefits are going to be more widely available. So for sort of COVID-related reasons, including people who are quarantining themselves, and there's no sick note required, which is a big change because normally you need to substantiate that you're entitled to those sickness benefits. There's regular EI benefits, which are, for people who are not ill, but have lost their income or their work for some reason, such as, they work in a museum and the museum's closed. And then work sharing, Danielle's going to chat about that, but the federal government has basically doubled the length of time that can last for, so up to 76 weeks, which is obviously a pretty long time. And that would be where you're reducing multiple employees' hours just because the work is less, but you're sharing the work among them so that you're not having to actually lay off or terminate anybody. And the work sharing waiting period or the application period process has been changed, as well as the sickness benefits waiting period has been changed. So people can start receiving those immediately. Normally, there's a waiting period there before you can actually start getting benefits. So, as I said, access to sickness benefits has been expanded, and this is like EI, so it's financial support to employees who are unable to work for the medical reasons related to COVID-19. So people who are returning from abroad, for example, who are now asked to quarantine for 14 days, they could be eligible for this, even though if they're not sick, like they're able to avail themselves of this. And these are just some other requirements. So as I was saying, the insurable hours, that's what employees will have had to bank for themselves. And then the maximum you can receive on EI is 55% of your normal insurable earnings. And I think that's like a maximum amount of about $560 a week. And again, there's no waiting period anymore for the EI sickness benefits, and no doctor's note is required.
Okay, work sharing. So work sharing is an EI program that both the employer and the employee have to agree to be part of, and both apply. So it's a program to help avoid temporary layoffs and reduction in workforce. It's available to both provincially and federally regulated employers. And so work sharing unit must reduce its hours of work by at least 10%, which is about a half day, to 60%, which is 3 days per week. And the reduction of work can vary from week to week, as long as the average reduction is between 10 and 60%, and that's over the course of the agreement. So when you enter into this work sharing program, you would enter into it for a certain amount of weeks. So your employees would be sharing the work that's available. And like I mentioned, both the employer and the employees must agree. The amount of time that you can be on the work sharing program is a minimum of 6 weeks and can go up to 76 weeks, which is quite an increase due to this COVID-19 pandemic. The max used to be up to 35 weeks. And to be eligible, you have to have been in business in Canada year-round for at least 2 years. Be a private business, publicly held company, or a non-for-profit organization. You need to demonstrate that the shortage of work is temporary and beyond your control. Demonstrate that a recent decrease in business activity of approximately 10%, so that there was a decrease of approximately 10% at a minimum. And you need to submit and implement a recovery plan designed to return to the work sharing individuals to normal working hours by the end of the program. And employers cannot make a work sharing agreement with employees who are seasonal workers or students hired for the summer or for a short period of time, or co-op students. Employees who are hired on a casual or on-call basis, or shareholders of the business whose shares provide them with significant decision-making power as to the direction of the company.
So, and I think just to comment on that recovery plan, I think that's going to be pretty challenging for us to anticipate at this point.
Right.
But I do expect that there would be some leniency with respect to that. I also just wanted to say we're getting some questions. We'll take a couple of the questions at the end. So I just wanted to let people know we are receiving your questions.
Good stuff. Okay, so now I'm going to talk about topping up EI benefits. So as an employer, if your employees are going to be receiving EI, you can choose to top up their benefits if you want to. So through this program called the Supplementary Unemployment Benefit Plan. So you can look that up. And you would be topping up your employees up to 95% of their weekly earnings, if that's the case, if you do decide to do that.
Okay, so some people have been asking about having their employees use their paid time off in this situation, and that's a good option. Employers do have the right to require employees to take vacation days whenever the employer wants. So you could, to allow you to keep paying your employees, you could pay them out their vacation. You could let them take their paid sick days now. And those are good options, in the short term. And that means, so if you pay them for 2 weeks of vacation now and they get 2 weeks a year, they won't get any other vacation for the rest of the year. It's obviously not ideal, but desperate times. Short-term disability benefits, we anticipate that those would be available for, people who are ill, likely, but that's always going to be up to the insurance company and their requirements for that. Workers' compensation, so WSIB, is something that may apply in this situation. And what we can say is just what we know from SARS, which is that when employees contracted the illness in the course of their job, they were eligible for WSIB and that's a type of employment income supplement benefit. So So if you did have an employee who contracted COVID at work, like a nurse, for example, or someone who's that's sort of like an occupational hazard, is where they're going to be coming into contact with people who may be ill, they might have a good workers' comp claim. But that, again, is going to be determined by WSIB. Accommodating people. So people are going to be obviously wanting to work from home, staying in quarantine, having to care for children where daycares and schools are closed, caring for ill people. So this proposed legislative change would give people in these situations job protection. So we wouldn't be able to terminate because someone had no daycare, for example, and needed to take care of their kids. Working from home is also probably a reasonable request to accommodate at this time. And if someone's still working, you still need to pay them, right? So even if they're working from home and their job looks a little bit different, if they're unable to work from home and they're not doing any work, then they're, on some sort of leave, be it a layoff or the COVID-19 leave, and they don't need to be paid for that time. Human rights issues. So I just want to touch on this very briefly. Sort of become less of an issue at the moment just because more things are closed, but you still do want to be aware as an employer that you're not targeting anybody in this situation based on a protected ground. So the example that I thought of was like, you wouldn't just fire all of your Italian employees because you're like, oh, they might, know people from Italy who might be a higher risk carrier or something like that. That would be discriminatory because you're basing that decision on the protected ground of their place of origin, and that's contrary to the Human Rights Code. Similarly, we can't target parents who have additional childcare responsibilities during this time. So they would have protection under the new leave that we're expecting, but also, you can't just say like, oh, you have little kids, you can't work from home because the little kids are there bugging you all day, so you're fired. That would be a violation of the Human Rights Code. And over to you, Danielle, for this one.
Okay, so if you find out that one of your employees has contracted COVID-19, the first thing that you should be doing is contacting public health. And what you can ask about is, disclosing to your other employees about the person who did contract COVID-19. So normally, you can't really just go and disclose people's personal health information. So that a person's right to have their personal health information remain private has to be balanced with, your duty to provide a safe workplace as an employer. So that's something that you can discuss with public health over the phone if you are in that situation. Another option is asking the person whether you can share the information with your other employees, because it's definitely going to be some important information for your workplace and for other employees to know. And not even the option of anonymizing the data and the person that has been infected or that has contracted the virus.
Yeah. So employees might need to know that they came into contact with somebody with COVID if it was in the workplace, but they don't need to know like, oh, it was Jane, So. Yeah. Yeah, but we do expect that should you be in that situation, there would be some pretty clear directives from public health in terms of what you're supposed to, who you're supposed to tell, and what you're supposed to do there. So we just wanted to mention employer liability here. So there's always a risk to employers when making lots of changes to the employee's employment and pay and benefits and hours and all this type of stuff, that the employee could sue the employer or issue a demand for, generally they're going to be asserting that they were terminated and inserting their right to termination entitlements. these are exceptional times. So, I think the employers may have a good defense in many of those cases, but let's say you're in the situation of you lay off an employee and the layoff goes for longer than the allowed time under the law, then that employee would be entitled to those termination entitlements. So employers need to kind of be aware of that. But I do expect that the new leave will give employers more flexibility, and we don't know how long the leave will be for at this time. Employers have an obligation under the Occupational Health and Safety Act in Ontario, similar acts in other provinces, to keep the workplace safe. So that means in this situation, taking precautions for extra sanitization, maybe like, I think, if an employer didn't allow their grocery checkout employee to like wear a mask and gloves if they wanted to, and then that employee became ill, I think that might be kind of on the employer, right, for not acting reasonably to keep that employee safe. Employees do have a right to refuse unsafe work under the Occupational Health and Safety Act, and if they do refuse to work, the employer is still obligated to pay them. But this is kind of a little bit of a different situation. It's we don't really expect this to arise too much, but if an employee is refusing to work under OSHA, they would be allowed to do so if they felt that the situation was dangerous, not risky. And what that means in our current situation, we don't really know, but that is just something for employers to keep in mind, and just employers to also keep in mind that they do have a duty to keep the workers safe under OSHA. So remote working. So a lot of people are going remote during this time. And we have lots of blogs on our website about remote working and how to do this well, what to consider. We're also providing a template remote working policy that you can grab off of our resources tab on our website, which is sort of outlines expectations for an employee and get your employee to sign that. So things you want to keep in mind are privacy. So if your employee is going to be like taking a bunch of work home or working on an unsecured network or things like that, your data may be at risk. So just turning your mind to that and putting that into the policy or requirements, like, make sure they have a good password on their Wi-Fi, and how are they going to maintain confidential documents if they're working at home? Will they be in a separate place, or will they be sitting at the kitchen counter with like their spouse able to read everything? So just turning your mind to that. And then connectivity is the other main thing. So what hours are you going to expect your employee to work? Like, working from home does not necessarily mean working flexibly, right? It may mean they're expected to be, seat in chair, connected and online during their normal work hours, and that's absolutely fine. So you just want to communicate those expectations and think about how you're going to communicate while working from home. So setting up some video chats, asking the employee to make sure they answer their phone when you call, what's the response time for an email that you're expecting, just to establish that trust that the employee is actually working. And, we find it works pretty well.
Yep. Okay. And finally, here are some resources that you can access. We just, included some links here, a link on the Government of Ontario News Update website, some information from the Government of Ontario on COVID-19, so information and updates for that, what the City of Toronto is doing in response, and some information here on the work sharing program. So you can, if you want to find out more about that, here's the website. And same with the sub-plan, which is the top-up, so topping up your employee's EI.
Great.
And that's it.
Yeah, so I'm just gonna take a couple questions here. So I see someone has done this. They've used the code other in the ROE and put COVID-19. So I think that's actually a good idea, because, as I said, likely there will be a code for that COVID-19 leave. So good ingenuity there. Someone's asking about a no daycare code. I'm assuming their employees unable to work because of no daycare. I think you could use our other attendees idea there and go with other, put COVID-19 no daycare in the ROE. That would probably be fine. Here's someone who's asked, I've hired an employee a week before the layoff happened. Will the employee be eligible for EI based on their previous employment? Likely they will if they had full-time employment prior. It doesn't matter if they've worked on different jobs. It's just the number of contributions they've made, in the past year, I believe. So they should be if they have those insurable hours, but obviously only working with you for 1 week, they wouldn't. And then I'm providing an ROE for 1 week that they're on a temporary layoff. Yeah, that sounds fine. If an employee wants to reduce their hours, does the employer have to pay their full hours? No, you only have to pay your employee for hours they're working. So if they're going to go down to 50%, you would be able to pay them 50% of their salary. I would suggest that be communicated in writing, so the employee make the request in writing and the employer say yes in writing, just to cover off any confusion that might result out of that. Or if the employee didn't ask in writing, the employer can just follow up with an email and confirm in writing. Here's a question regarding the privacy situation. If the employee, I'm assuming this would be an employee with the COVID-19, says they don't want the information shared, and this person is right, the employer does have a duty to protect their other employees in the public and in retail. How should this be handled? So, I think you should contact public health, but likely, in order to respect that employee who doesn't want their information shared, likely you just end up not telling anyone who it was, right? So one of our employees, or we know that someone in the store, something like that. But I do expect that public health has some protocol with respect to how contact tracing should be done and who needs to be notified. But you're absolutely right. You do have an employee. You do have a duty to keep those other employees safe. So when layoff clauses are not in current contracts, and employers are wanting to do a layoff anyway, one thing we're suggesting, so I think it does depend on situation to situation, and in many cases, we're going to say, get legal advice specific to your situation. I do think in many cases, the COVID leave, which we expect to have more information on tomorrow, might be a good workaround for people in this situation, because it will kind of have the effect of a layoff, where the employee doesn't come to work and the employer doesn't have to pay. But we will see more information on that hopefully soon. Do you need to provide a letter to an employee you are laying off? In Ontario, there's no written requirement for a layoff. Other provinces are different. Alberta, for example, you need to provide it in writing, and you need to provide them with notice. So you need to tell them in 1 week or in 2 weeks, if there's a longer service employee, you are being laid off, and you have to pay them for that week leading up to the layoff or 2 weeks leading up to the layoff. So it doesn't have to be in writing for Ontario, but even though it doesn't have to be in writing, we think it's always a good idea to put everything in writing. So it generally is not going to hurt to have it in writing. Can we suggest to employees that they volunteer to take a sabbatical or reduce their wages for the time being? Yeah, you can suggest that. And if an employee agrees to an alternative work arrangement, like taking a sabbatical, yeah, like whatever, if they're agreeing to it and if they feel like they're doing it voluntarily, then I think you're good to go there. But employers can't, you couldn't like force your employee to take a sabbatical because that would look like a termination and that would trigger termination entitlements. So it does need to be voluntary. But I think in a lot of these situations where we're kind of in gray areas, if the employee agrees, as long as the employee is okay with it, and I think a lot of employees are going to be okay with sort of different situations, just given that there's a lot of people who aren't going to get paid at all or aren't going to have jobs at all in this situation, then I think the risk to the employer is low. Can employees volunteer for layoffs, allowing the employer to lay off those in higher seniority where there's a collective bargaining agreement in place? So where there's a collective bargaining agreement in place, generally there is an order of layoffs, right? So that would need to be followed generally. If employees are volunteering and that somehow disrupts the order, as long as they're not going to grieve, right, then you're probably fine. But I think that's probably very dependent on the specific collective agreement. So big asterisks around that answer. And then someone's just noted that public health has great resources on their website, infographics that employers can use. So that's a great tip. Thank you. Let me just see. Someone is asking if their U.S. head office wants them to use forehead thermometers to take temperatures of employees at the distribution center. I assume this distribution center is in Canada. That's a tricky question. I would say probably that's a bit extreme. In normal circumstances, I would say, no, you can't do that. But yeah, I mean, current circumstances, maybe it's warranted. I don't know. Do you have any ideas about that one, Danielle? Forehead thermometer as you're coming into work.
I mean, if the employer would argue, I'm guessing that they're just trying to provide a safe workplace, right?
Yeah. Which is definitely a consideration.
Yeah.
Mm-hmm.
I wouldn't have a problem necessarily with that. But I mean, we're answering these questions, but really, if you have a specific question that hasn't been answered, we recommend that you reach out. What we're providing right now basically is legal information. So
yeah,
we would need to know more detail if you have like a more specific question in order to be able to really provide you with a fulsome answer.
And someone's asking about, I'm assuming, layoff laws in Newfoundland. I don't know if the layoff laws in Newfoundland off the top of my head, but it should be fairly easy to find. If you just Google temporary layoff Newfoundland, I would expect the government of Newfoundland has a pretty good website that sets that out easily. And it's going to be something like 13 weeks in 20 weeks or, 8 weeks in 60 days or whatever. So, you're looking for something in that kind of configuration. But if you're unable to find that,
and we don't know if.
Go ahead.
Yeah, and we don't know if that might be changed. We just don't know yet what's going to happen. To these layoff requirements.
Mm-hmm, mm-hmm. Yeah, and I mean, we're focused on Ontario today, and we know that the Ontario Employment Standards Act is being amended to add this COVID leave. I believe Alberta also announced that they will be amending their Employment Standards Act to include something similar. But yeah, other provinces I think are likely to follow suit. So the law is certainly rapidly evolving in this time. So I think we will just wrap up. If you did have a question that you didn't get answered, feel free to reach out and we can set up a consultation for you with one of our lawyers. This is our free monthly webinar, so we did have a different topic planned for today, but we decided to change it. So we'll see what next month holds, but you can check out our upcoming topics on our website. I think we have plan to talk about litigation and employment law litigation and how that impacts employers, how to avoid it, that type of thing coming up. And we've got some other great topics coming up. So yeah, and we'll keep you posted. You can join our mailing list where we are sending out our FAQ as we're updating it, and our monthly newsletter with our blog, which is a great resource as well. And yeah, follow us on Facebook, Twitter, LinkedIn, Instagram, just to stay up to date on the latest information. And thank you for joining us today. Apologize for the technical difficulties and running over a little bit there, but we hope everyone enjoyed the presentation and that was valuable.
Be well.
Yeah.
Here.
Bye.